Hi, hello everybody. This is Uma from Success Law Classes. Today we are going to discuss the Registration Act 1908. These important for the candidates who are going to appear and who are going to prepare for junior civil judge exam and district judge exams. This video is important for prelims as well as mains exams. So let us start. Before starting, I request all of you to please subscribe my channel and please click the like button. So coming to Registration Act 1908, the main object of this act is to legally recognize the transactions that have taken place between the parties and thus recognizing the rights and liabilities of the parties, to give information to the public about the rights and obligations in relation to particular property. Here the registration is a public notice. Registration is done to prevent frauds, to provide safety and security of the transactions, and to perpetuate the documents that may be of legal importance. And one of the important for object of this enactment is to provide revenue to the government. These one of the object of this Registration Act. So coming to the Registration Act, this enactment came into force from 1st January 1909. So let us start the question that we can expect in judicial service examinations, that is for junior civil judge and district judge examination. If you can see previous question papers with regard to JCJ and DJ exams, you will find these questions. So the question is, the most important question under this enactment is documents of which registration is compulsory. So here, according to section 17 clause 1, in case of the following documents, registration is compulsory. The first is gift of immovable property. In Kalyana Sundaram Pillai versus Karupa, Mupnar 1927, this is Privy Council case. In this case, the court held that when the donee accepts the gift and takes possession of the property, the gift is valid, though the gift it is not registered. So here, every gift of immovable property must be registered as per section 17 clause 1, but if the donee accepts and takes possession of that immovable property, then it is not compulsory as per this Kalyana Sundaram Pillai case. Then coming to the next document that requires registration is leases of immovable property. So as per the Amendment Act 1999, in AP, every lease should be registered irrespective of duration. So leases of immovable property should be registered in AP, even it is for 3 months or 4 months, it should be registered as per the Amendment Act 1999. Next document is any other non-testamentary document that creates any legal right, title or interest in the immovable property of value ₹100 or upwards. So here non-testamentary document means the document come into existence during the lifetime of both the donee and the donor, that is seller and the purchaser. So the non-testamentary documents here are sale deed, mortgage deed, partition deed, exchange. Pasupu Kunkuma. Pasupu Kunkuma is nothing but the gift given to the daughter at the time of marriage, and a charge created by an agreement by the parties but not by the court. So these are the documents which require registration. Next, coming to power of attorney, which confers power to sell the property, shall be registered but not general power of attorney. So here when the power of attorney is given conferring the person to sell the property, then it should be registered but not a general power of attorney. So in this you can refer Suraj Lamp and Industries Private Limited versus State of Haryana and another's 2012 case, in this case with regard to power of attorney. Next, coming to the document, non-testamentary document which acknowledges the receipt or payment of any consideration. So any non-testamentary document which acknowledges that some consideration has been received by the seller or the vendor, that should be registered as per section 17 clause 1. Next is non-testamentary document transferring a degree. So here degree means if A got a degree in his favor with regard to a particular immovable property, to transfer that degree to some other person, registration is required, and also an order or award of court relating to immovable property. So if any person, any degree holder want to transfer the property which he got through degree, that is with regard to immovable property which is more than 100 rupees value, should be registered. Then coming to an agreement of sale of immovable property of value of rupees 100 or upwards. So here an agreement of sale of an immovable property should also be registered. Next, coming to according to section 17 clause 3, the authorities or the power to adopt a son shall also be registered. So if any person is given authority to adopt a son, example A, for A, if he want to give any power to any person to adopt son for him, then that should be registered. To adoption, it need not be compulsory registered under this act, but if authorization for adopting a son has been given to another, it requires compulsory registration. So this is with regard to documents which are compulsorily registration is required. Then coming to the second question that we can expect in mostly in examinations, if you check previous question papers, that is documents of which registration is not required and optional. So here section 17 clause 2 deals with documents which are registration is not compulsory and it is an optional. So the first document is allotment of shares or issue of debentures. The second document is transfer of shares or endorsement of debentures. Then coming to third is any grant of immovable property by government to the landless poor people. So if any land is given by the government to landless poor people, that is also need not be registered. They will give patta lands. Then any instrument of partition made by a revenue officer at the direction of court or at the direction of government. So if any partition is done by the revenue officer on the instructions of court or government, that also need not be registered. Then any certificate of sale granted to the purchaser of the immovable property sold by way of public auction by civil or revenue officer at the order of the government or by the court. So if any certificate of sale is granted to the purchaser with regard to immovable property which was sold by the revenue officer in public auction as per the directions of the government or by the court, then that also need not be registered. Here the according to section 89 of the act, after completion of sale, the court shall send a copy of such sale certificate to the registrar and he shall record such sale. Next, coming to any order of granting a loan under a special law. So if any order is for granting of loan under any special law is given, then that also optional to register. Registration is optional here. Example, Agriculturist Loans Act 1884, the Land Improvement Act 1971, etc. Next is any composition deed. So these are the documents which registration is optional as per 17 clause 2 of Registration Act. Next is documents of which registration is optional is section 18, deals with documents of which registration is optional. So here registration of a will or depositing of will is optional, but attestation is compulsory. So registration of will is not compulsory or deposition of will is not compulsory, but it is optional, but attestation should be must be done in that will. then only it is valid. Then coming to any other instrument of which registration is neither compulsory nor not required, it is optional. So this is with regard to Registration Act Part 1. Thank you all of you. Please subscribe my channel and please click the like button.